Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, November 13th, 2024. In this week's episode, rap mogul Sean Diddy Combs' latest plea for bond as a judge denies a gag order in the case. Plus, a babysitter charged with an infant's fatal Benadryl overdose. But first, a man's conviction for the murder of two teen girls in Delphi, Indiana brings closure to a case that has captivated true crime audiences for the better part of a decade. Today, we're very happy to be joined by Dave Aronberg, a former state senator, the state attorney for Palm Beach County, and the host of True Crime MTN on YouTube. Dave, welcome.
Hey, Josh, great to be with you. Thanks for having me.
Oh, absolutely. What people don't know is how busy you are. We're fitting you in between TV appearances, so we're so grateful for that. We know that you are one of the go-to legal analysts. So I'm not going to waste any more of your time giving you accolades. Let's go ahead and jump right into these cases. Out of Delphi, Indiana, more than 7 years after the murder of two teen girls on a remote hiking trail, long-awaited justice has finally been delivered to their families. Jurors deliberated for around 19 hours before convicting Richard Allen of the 2017 murders of Abigail Williams and Liberty German on the Monon High Bridge Trail in Delphi, Indiana. The case has long been the subject of speculation in the true crime community, due in part to a cryptic video recorded before the grisly murders, with the suspect uttering the phrase, "guys down the hill." Prosecutors sought to prove that Allen was the man in the grainy footage and used an unspent bullet recovered at the scene to tie Allen to the crime, where they claim he kidnapped the girls before slitting their throats. Prosecutors also contend that Allen had confessed to the crime more than 60 times after he was arrested. Allen's defense maintained that these were false confessions made by a man in a deteriorating mental state. Before trial, Allen's defense delivered a bombshell claiming that the killings were sacrifices made by practitioners of a pagan faith with ties to white nationalism. However, motions to introduce this theory were repeatedly rejected by the judge, leaving Allen's defense with few options to cast doubt on the state's case. Ultimately, their efforts were unsuccessful, leading to Allen's conviction for 2 counts of murder and 2 counts of murder while kidnapping. Allen is scheduled for sentencing on December 20th, and he could face up to 130 years in prison. Meanwhile, a gag order still remains in place on the case. Dave, jump right in. I know you follow this case closely. Were you surprised at all by this verdict?
I was not, because a confession is a confession, and here you had more than 60 of them. And I know the defense made great hay over his mental state, and they brought some very credible experts to the stand to say that he really did have some delusions, and that could explain his confessions. But 60 of them to family, friends, and he was talking about that he was the one who killed Libby and Abby, and when you combine that with the unspent bullet, which, although it didn't kill the girls because the girls were stabbed to death, but you combine the bullet on the scene with it matched the caliber of his gun found at his place. And then he also fits the description of the person on the video who was seen on that short video taken, which looks like that was the killer. I mean, you put that all together and it's enough for a conviction. And, I know a lot of people were thinking that the defense was going to raise reasonable doubt because of their expert witnesses and their powers of persuasion, but the evidence is what it is, and confessions are direct evidence, and that, to me, is the most powerful evidence in this case.
I agree with you. I mean, I've said it again and again that the most powerful evidence you're going to have in a case as a prosecutor are words out of the defendant's own mouth. If that's him taking the stand, if that is him speaking to police during an interrogation, or if that's him making confessions like he did to his wife and other jail personnel while he was in custody, that's going to be very, very convincing stuff to the jury. This case was also received a lot of criticism because of the extreme restrictions that the judge placed on the media in this case. There were no cameras inside of the courtroom. But on top of that, there were no electronics afforded to the media. So they had to take all of their notes handwritten. There was a sequestered jury, and I'm talking really sequestered, in a hotel room, no electronics for them either. And a gag order still remains in place. What do you make of all of this? And do you think that that may have fueled some of this distrust that we see about this verdict?
Yeah, perhaps. When you have a sequestered jury, it does put pressure on the jury to act faster than they would otherwise because they want to go home and see their families. And so if you have a holdout, that holdout is probably a little more willing to give in, knowing that they are the only thing standing between them and reuniting with their families. So I get it. Plus, they weren't even allowed to watch TV. They had to have supervised viewing of certain things, and no one wants any of that. So yeah, they did take it very seriously. I think the only thing I would disagree with is the gag order that remains. I know they want to keep it at least through sentencing, but I think after the verdict, I don't think you necessarily need to have a gag order, but they've been really strict in this case. I'm always for cameras in the courtroom. I think transparency is better. But in the end, I think justice was done. And if there was a grounds for appeal in this case, it's not going to be because of that stuff. It would be because the defense was not allowed to admit that pagan worship theory, which I think is pretty outlandish, but it's something. To me, that's the only way they could get this overturned.
Yeah, touch on that a little bit for us, because the defense presented this theory that there was this cult called Odinism, and it wasn't just that they had picked this out of nowhere. There was something about the way that the girls were found that they believed it was staged, and they believed that the way some of those branches were left to, the prosecution argued, conceal the bodies may have been actually symbols of this cult. Now, I understand a judge wants to keep a case clean, doesn't want a case going off on these red herring, wild goose chases, doesn't want to confuse the jury. But at the same time, doesn't a defense, aren't they entitled to at least establish that maybe police ignored some things? What were your thoughts?
Yeah, and there was a search warrant apparently from an FBI agent that mentioned that he thought that the crime scene was possibly staged. So that would feed into this whole Odinism thing. So that is the one ground on which they could possibly win on appeal. But it is the judge's decision. You don't want this trial to be a circus where the jury is sent all different ways, looking at things where there's no evidence of it. And just because the bodies may have been moved and there was a lot of blood, it doesn't mean that there's some weird pagan ritual out there. I think you'd have to have a little more evidence. That's what the judge was thinking. I'm not going to let you go on a wild goose chase here. You got to give me some real evidence other than just your speculation. And we've seen how speculation can get a reasonable doubt, and reasonable doubt gets you an acquittal if a defense lawyer is allowed to go far afield. But here the judge kept it tight, just like they kept the trial tight and not allowing cameras and keeping the jury sequestered. So in the end, I think justice was done. But yes, I think there is a chance that it could be overturned on appeal for the reason of not allowing that bizarre theory into evidence.
Last question on this is that a lot of people who were in the camp that felt that there was reasonable doubt in this case based a lot of that on the conditions in which Richard Allen was held in custody during his time pending trial. And the defense put on evidence that he definitely did seem to be suffering from some sort of mental decline. And it shed a lot of light on the fact that this person is being held in solitary confinement for over a year. And those conditions were, a lot of people called them harsh to borderline unacceptable. Do you think this case moving forward will kind of shed some light or change some things as far as how defendants are held in custody before their trial even begins?
Not so sure. There are a lot of defendants who are held in solitary confinement, and they don't respond by issuing 60 different confessions. I had a case where the defendant was held for 5.5 years in solitary confinement, and that was at the request of the defense lawyers because they didn't want her talking to others. They didn't want a jailhouse snitch. So a lot of times these defendants are kept in solitary confinement at the request of their own lawyers because they don't trust their clients. So that has to be put into consideration as well. So whether his 13 months in solitary confinement resulted in him in his 60 plus confessions, I doubt it. There are a lot of defendants who are kept in solitary confinement and they don't respond by blabbing confessions. So I think that is something for the defense to try to make hay on appeal. I don't think it's going anywhere.
Yeah. Well, thank you again for all your thoughts on this. I know you followed this case closely, and that's why we appreciate hearing from you.
Are you confused about when and how to start investing? I remember when words like IRAs and portfolios were another language, but investing doesn't have to be scary or hard. Today's episode is sponsored by Acorns. Acorns makes it easy to start automatically saving and investing for you, your kids, and your retirement. You don't need a lot of money or expertise to invest with Acorns. In fact, you can get started with just your spare change. Acorns recommends an expert-built portfolio that fits you and your money goals, then automatically invests your money for you. And now Acorns is putting their money into your future. Open an Acorns Later IRA and get up to a 3% match on new contributions. That's extra money for your retirement. Investing and planning for your future can be complicated, but it's important to think ahead and prepare. Acorns is a great and easy way to get started. Head to acorns.com/truecrime or download the Acorns app to start saving and investing for your future today. Paid non-client endorsement compensation provides incentive to positively promote Acorns. Investing involves risk. Acorns Advisors LLC, an SEC registered investment advisor. View important disclosures at acorns.com/truecrime.
Let's move to Honolulu, Hawaii, where a trial is underway for a babysitter charged in the Benadryl overdose death of an infant. This week, the defense delivered a tough cross-examination of the victim's mother. Dixie Denise Villa is facing a charge of manslaughter for the death of a 7-month-old Abigail Lobish, which prosecutors alleging Villa gave the child a fatal quantity of Benadryl to get her to sleep. Victim's mother, Anna Lobish, testified about the day she arrived at Villa's residence to the sight of EMTs who told the mother her daughter was dead. As Lobish struggled to stay composed through her emotional testimony, Villa's defense sought to poke holes in the woman's claims. They alleged that Lobish confessed to taking Tylenol PM while breastfeeding the child and even admitted to a friend that she feared her breast milk would be tested in the course of the investigation, though ultimately investigators neglected to do so. Whether Villa's defense has sown seeds of reasonable doubt in the minds of the jurors remains to be seen, but we will continue to follow this trial as it proceeds. Dave, as a prosecutor, you've had to cross-examine folks, and sometimes you have to read the room and understand that the person you're cross-examining has to be treated with a bit of a softer touch. Was the defense treading on thin ice here to cross-examine aggressively the mother of a 7-month-old victim?
Yes, but they really had no other choice. The only chance to get a hung jury or an acquittal in this case is to show that the mother gave the baby something that then led to her death, that it appears that the baby died from an overdose of this, was it diphenhydramine? It's hard to pronounce it. It's toxicity that was found that was more than double the amount that's fatal in infants. And it was found in her blood and her urine. And so the defense is saying, well, it came from the mother, Tylenol PM. But then the expert on the stand said, no, it could not have been Tylenol PM because Tylenol PM has acetaminophen in it, and there was not enough acetaminophen, and so it was not present in the toxicology test, so it had to be Benadryl. And who gave the baby Benadryl? That's the theory of the prosecution, that it was the caregiver, the unlicensed caregiver, mind you, the babysitter that was unlicensed. So the only chance the defense really has is to lay the blame on the mother, but that is where you're skating on thin ice, Josh, exactly, because the mother is grieving, and if you go too hard at her, you are going to cost yourself the case. So it's just like a wire thin move where you try to balance yourself, and it's very hard to do. And I think in the end, this is heading towards a conviction.
I think I agree with you. But one mistake, I think, and I'm curious to hear your thoughts, that the prosecution, or rather the investigation, may have made in this case is they never did drug test the mother, which that would seem like if you're trying to determine how drugs got into this baby's system, one of the people that you might want to test is the mother who happens to be breastfeeding that child. Do you think that that was a big enough mistake that it might create some doubt in these jurors' minds?
Well, if the mother there was some evidence that she was taking Benadryl. Apparently, she was taking Tylenol PM, and there was no Tylenol PM found in the toxicity report. So I think that you'd have to believe that it was the mother who gave the child excess Benadryl when it was pretty much, I think, proven that the babysitter gave the child, the baby, Benadryl. So that's where I think, I don't know. I don't think that the mother in the end will be blamed for the baby's death, especially when you have a grieving mother on the stand who came off pretty well. And the jurors are looking to see, should we victimize the mother twice? First, she's lost her baby to this unlicensed caregiver. And then secondly, we're blaming her for her baby's death. I don't think it's going to happen.
Yeah, powerful stuff. Really powerful emotional arguments that can sometimes be overlooked when you're trying to analyze these things from a legal perspective. Last question on this. End of the day, this case, one of the biggest questions is going to come down to intent. Mm-hmm. You know, did this babysitter intend to cause harm to this child, even if she did give her Benadryl? Do you, as a prosecutor, how would you try to handle that and explain that to the jurors?
Well, you don't necessarily prove that the babysitter intentionally wanted to harm the child. You can show extreme recklessness that showed that, yeah, you wanted this child to go to sleep and you overdosed her and you didn't intend to kill the baby, but you acted so recklessly. And why? Because you're someone who had other children there, who was overwhelmed, who's unlicensed, who should not have been holding yourself out as a competent babysitter in this case. And so that's why you're guilty. And it could be just as bad as if you intentionally did it, depending on the charge and what the jury thinks. You can still be held guilty for manslaughter, for even murder, depending on the details of a case, even if it's not intentional murder. So the defendant here is facing years and years in prison, regardless of whether she intended to kill the baby. And I don't think she wanted the baby to die. How would that suit her? She knew that the mother was coming over to her place to pick up the child. So I think in the end, she'll be found guilty, but it won't be because she tried intentionally to kill the child.
Excellent points. And of course, in true prosecutor fashion, you continue to drive home that point that the babysitter was unlicensed. Not a small issue. And it's something I think they will absolutely drive home when they do their closing arguments in this case. They should be taking some notes from you, by the way. Let's move to New York, where ahead of his criminal sex trafficking trial, rap mogul Sean Diddy Combs is again seeking bond, offering a staggering sum for his pre-trial release. After 3 unsuccessful previous attempts, Combs' defense is now offering a $50 million bail package, which would be backed by the recording artist's $48 million Miami home. Just let that sink in for a moment. As part of their offer, Combs would also be subjected to home detention and monitored by 24/7 security personnel to ensure the rapper has no contact with witnesses or the alleged victims in the case. Whether this deal will be enough to change a judge's mind remains to be seen, with previous attempts at bail stymied by concerns of witness tampering or Combs' resources and ability to flee justice. A video of Diddy assaulting his then-girlfriend Cassandra Ventura was also cited in a denial for Combs' bond. However, his defense contends that this surveillance video is not evidence of a quote-unquote freak-off or the sex trafficking charges facing the magnate. In the meantime, Diddy's alleged victims will be able to speak publicly about their experiences after a gag order filed by Combs' defense was denied. We will continue to follow this case and update you as we have more information. Dave, I want to first get into this gag order request made by the defense. I'm really curious to hear your thoughts. Many people are saying that this is really just an attempt, instead of just to make this case fair, it's an attempt by his team to kind of roadblock these numerous civil cases against him and maybe even give a sneak preview of the witnesses against him. What are your thoughts?
Yes, the government really benefited from the denial of pretrial release. And because the the defendant is stuck behind bars. Now, all of these victims, alleged victims, are coming forward. They feel emboldened, empowered. They feel safe to do so. And they've got a private lawyer, Mr. Busby in Texas, who has more than 100 of these individuals. And so you can see that if the defense lawyers are not able to get their client out of jail pre-trial, the next best thing is to gag everyone, saying no more talking about this stuff, because they worry that it'll encourage more people to come forward. That poses problems. It could taint the jury pool. And also, if he ever gets out of these charges, he loses in the court of public opinion every time a story is out there. So you can see why, if he can't get out of jail pre-trial, the next best thing for the defense is to gag everyone involved. But he's been unsuccessful at both.
Yeah, and unsuccessful now once, twice, perhaps a third time. I'm curious, how many times is he allowed to keep on coming back with this? And I'm also curious to hear your thoughts on what they're offering. Is pretty incredible. I mean, it's a tremendous amount of money. And then they're basically saying, put 24-hour security on our guy. If you're really worried about him going anywhere or intimidating anyone, we're willing to allow you to surveil him around the clock. How could that not satisfy the concerns of the court?
Well, the problem is one of the judges said that this is a crime that occurs in secret. This is a crime that occurs behind closed doors. So unless you ban and have a way of preventing anyone else from entering his home and his room, then it could happen. You could have more human trafficking. You could have more freak-offs. You could have more sexual activities. Whatever it is, this is the type of thing that happens in secret, behind closed doors. And so when he says, allow me to stay behind closed doors at my place, you can see why the government's like, no, and the judge's like, I don't know. And I agree with the prosecution and the government, and the judge, because also if you allow Diddy to walk out pre-trial and others don't, you're saying, well, if you have money, if you have privilege and prestige and power, you get special treatment. And I know that happens in our system, but it's not a good look.
Yeah, I think that last point may be a point that nobody's talking about, but may actually be weighing a lot in the judge's mind. It's one thing to offer a bunch of money, but if the judge were to accept that, doesn't that just look like rich people buying themselves out of trouble? The more money you throw at the problem, the easier it's going to get for you. I've had situations myself as a defense attorney where we have offered to the judge to pay fines, and the judge said, I would rather see something like community service or something that any other person could do, rather than it making appear as though they're just kind of throwing money at an issue. You think that's what's happening here?
Yes. And I do think that the judge knows that the world is watching, and you want to be the judge, especially when other judges have said no. You want to be the judge who steps up and says, yeah, Diddy, go ahead. You get out, and you're allowed. It would look like a two-tier standard of justice. On the other hand, you don't want to treat him worse than everyone else because of a celebrity. You want to treat him the same way. So I get it. It's just that because the crimes alleged are really, really heinous and all done at his home and behind closed doors and other people's homes and hotels, when you're saying, give me house arrest, like, that's where the crimes occurred. So I get it why they said, no, you're going to stay behind bars. Plus, you see over 100 victims have stepped forward, alleged victims, and that's in part because Diddy is locked up. And if that changed, then perhaps people would not be coming forward like they are now.
And to that point, they're coming forward and they're taking part in a grand jury, which is currently convened, and they're testifying in front of that grand jury. What does that mean? Do you think there might be more charges on the horizon?
I fully expect a superseding indictment, which is an amended indictment where you'll have more counts, more victims, and possibly more defendants. Some of these celebrities out there are reportedly paying off alleged victims to keep them quiet. Well, we'll see where that leads if that's true. But I do think this is just the beginning of everything, not the end. And as far as these charges against them, the only person mentioned in the sex trafficking charge is victim number one. And that apparently is Cassie. No one else is mentioned. But yet we've now seen more than 100 people come forward. So I do anticipate that will change.
I think you might be right. I think your point earlier about The second he got into custody, the floodgates opened, and all these people who were in fear now no longer feel that this man is watching them and could easily reach out and hurt them. And I think you might be right. I think we might see a superseding indictment with many, many more counts than what we're looking at right now. Dave, thank you so much. This was fascinating stuff to hear your insights on these cases. Where can people find out more about you?
Josh, thank you. I have a YouTube channel, True Crime MTN. That stands for Midas Touch Network, True Crime MTN. And it's a different format. We do our short little videos about true crime cases. And so, Josh, I love what you do. And hopefully there'll be more viewers and eyeballs for all of us, because in this crazy political time, it's nice to have something that everyone from all sides of the aisles and politics and ideologies can agree on, is that true crime is fascinating stuff, and we all hate crime. So check us out.
I couldn't agree with you more. And do yourselves a favor, everyone, and check it out. Dave does some really incredible stuff. If you've enjoyed his thoughts here today, you get even more of that on his channel. And I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear more of my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you got questions or comments you would like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.